Sasha? Okay, so we're about to start the recording. Thank you everyone for joining. ACOS is hosting a series of webinars that is going to focus on a variety of different things. This webinar that you've logged on to right now is part of a series called Doing Business in the US, and it's specifically around the process of going through an IPO. We host these webinars as part of some of our chapter events. So right now we're at CFGI's office in Boston within the New England chapter. And future webinars will be in different chapters. But again, the purpose of having these webinars is so that our ACOS members across the nation will be able to come and see what everyone has access to nationwide. So without further ado, I'm gonna let May and Ryan present. So go ahead. Yeah.
The next slide introduces them.
Yeah.
Just taking it through a very high-level IPO process in the U.S. So hopefully it will be beneficial for you guys. So just a very brief introduction of myself and Ryan. I'm a senior manager at CFGI. Lately, I've been helping and leading a few IPO processes and reverse merger. So I definitely love, in transactions and IPO process. And I thought when the opportunity came up to present it, I feel like, oh, that may be something that could be useful for our community. A little bit of my background prior to coming to the U.S., I was a chartered accountant, and I'm still a chartered accountant, but I registered in Australia. So I was with Ernst & Young in Australia, Sydney, for several years before making the move to Boston. And then I have my.
So my name is Ryan Dolan. I'm a partner with CFGI, and I co-lead our life sciences practice. So, sort of as a result of the surrounding markets, I'm involved with a significant amount of IPOs. I'm going to scooch in here, sorry. A significant amount of IPOs with the biotechs primarily. So what we'd like to do is kind of take you through a high level some helpful points and helpful, considerations that an IPO process entails.
So this is the agenda that we would like to go through today in terms of going through an IPO. Okay. So first of all, we'll go through, what are the trading platforms in the U.S. and then how do we normally see company goes public? Who are the key players in the process of going public, IPO or other ways of going public? What's the timeline on registration process? What does it mean by foreign private issuers? That is particularly important if we have companies outside of US want to actually trade or list on our US stock exchange. Jobs Act is definitely important to know about, especially for those emerging growth companies. Why is the age of the financial statements why is it important, and what needs to looked at? And lastly is the common US GAAP accounting and SEC reporting considerations. A lot to cover. So first of all, there's definitely three ways of going public and the trading platforms for the securities in the U.S. Usually, in my experience, I've seen most of the companies list on NASDAQ. Obviously, we have those big names list on New York Stock Exchange, being the oldest stock exchange in the U.S.
I will say, one just comment on that, the New York Stock Exchange is actually making a significant push and offering incentives to biotech companies. They have a practice kind of, with an initiative, I'll call it, to kind of catch up with the NASDAQ. So, that's something you think about to, consider both exchanges if your company is going through the process.
Yeah. So what I have there as the requirements, so there are requirements when you wanted to list on those two exchanges, and they looked into a few different standards in those requirements, whether how much market cap you need to get, and some are I'm not sure if, so market cap is definitely one of it. Trading volumes is the other one. And what I have here is, there needs to be a minimum stock price that you need to meet while listing in those two exchanges. The NASDAQ, as you can see, there's like 3 different markets on that NASDAQ exchange. And each of those markets have different requirements. So those who are interested definitely would need to sort of look up into what are the requirements on each of those different exchange and markets. The last one, over the counter, is still exists for a company that wish to go public but could not meet the either trading volume as a start or the $4 minimum stock price. So what are the ways to go public? So we have, what we've seen very commonly is either reverse merger, where there's 2 types of reverse merger that we wanted to think about. First is, a company that the one that wants to go public purchase a shell company that's already public. There's a shell company that's public. And that is seen under SEC as a recapitalization, and that sort of drive like what type of form and path registration, what kind of statement that you need to actually file as part of the going public process. The other way is you actually purchase an existing listed company, means a company that's actually have business in it and is running as a business and meet the definition of business. And in that case, it will be a business combination, and hence you will have a different form that needs, like different registration process that need to go through in different form to meet. And usually you hear about what's Super 8K and S4, and that's on a very high level, the distinction.
Yeah, so this has become the reverse merger has become a lot more common in the past few years, a common method of going public. It used to be sort of frowned upon by the SEC. Maybe 10 years or so ago, there were a bunch of Chinese companies in particular that were kind of using this as a route to a backdoor IPO. And so that kind of gave it a bad name. The SEC hated it, would review any reverse merger that was coming across, with a fine-tooth comb, go through it. It's become, a lot less, a lot more common and sort of, a lot more part of the normal practice. So, with emerging companies, development stage companies, what we're seeing is, companies that go public several years ago, don't do so well, perhaps, find themselves, biotechs in particular, find themselves with a whole lot of cash and maybe a failed drug or a failed pipeline. And so what happens is, a company that is a private company, perhaps in the same industry, perhaps not, is looking at that company as a good target to purchase, both for the shell company that is a public entity already, and for the cash it has on hand. So it's sort of a financing and a way of going public at the same time. So for that reason, it's become a lot more popular. Still sort of it comes with its own risks. You're essentially combining an acquisition and going public in one transaction. So there's it's not the cheap, easy IPO that some people think it might be.
Yeah. So then the other way of more commonly known going public is an initial public offering, often called as IPOs. And over here, there's obviously 2 ways. One, 2 forms that we would file depends on the locations of the companies and the residential status of companies. S1 is the more commonly known registration company for all the domestic, i.e. US companies, and Form 20F for foreign private issuers. And we will talk about.
So it would be a Form F1 for the registration statement itself, and then 20F is the is sort of the akin to your 10K for a domestic registrar.
Yeah, Form F1 then. Thank you.
Can fix that one.
Okay. So what does that mean by IPO? Obviously, it's first sale of shares by a company to general public. Is where private company then becomes a publicly traded company. And there's a lot of navigation going through that process from a lot of filings, compliance stuff that we need to do to meet it. But from a business perspective, there's also a lot of marketing, talking to investors and exploring, making sure publicity about the company to go public. So who are the key players in the process of going public? So we have basically the registrant, being the management, and the finance team will be heavily involved in here throughout the process. You have the registrant SEC counsel, often in charge of the process, and usually those are the lawyers that are very that knows the process inside out. You have the auditors, obviously, because you need their, you need them to sign off on financial statements, and you want their assurance on all those financial statements before going public. And consultants, that is more to talk about in our subsequent slides. As you can see, this is going to be a very intensive in terms of time and the volume of data and reports and work that needs to go through. Usually that is on top of the day job as well, so that comes handy. And then
just real quick right there. So what we find is it adds a second job for especially the finance team, which I think includes all of us here for the most part. It winds up being a second job. So what we kind of recommend is you should be you're the senior management in finance at the registrar or the company that's going public. Should look at yourself as sort of the traffic cop. There are 8 other parties that you need to be directing, and that you are the client. So use all of those parties to the fullest extent you can. You're going to find that's the only way that you can kind of get through these things efficiently. As we know, it's always the accountant's fault when things get delayed. So it's also your job to kind of manage all of those different parties and expectations.
Yeah. And going through the list, there's underwriters. That's very important because they basically is the the key to a success IPO as well, and is a key business partner to work with throughout the process too. And the registration statement is mainly a marketing tool for the underwriters. And then you have the underwriters council that usually would, basically they are also the SEC expert, want to make sure that everything that's being disclosed in the registration statement are things that they can talk to and hold up on their tour. And then you have other advisors and valuation experts in that process.
So that's why you see the emails. If you've ever been involved with one of these processes or ever in a deal of some sort, that's why you see the emails with 800 people CC'd on them. Lawyers and lawyers and lawyers. They love all of this. You have 2 sets just for the the company's lawyers, company's SEC counsel, and the underwriters' lawyers. And you might add some patent lawyers on in there, and all of a sudden you've got an expensive set of emails.
So how does the timeline of registration look like? So first of all, you will, management decide to go on it. Then you have identified, underwriters to work with. Therefore, first of all, you start with an org meeting or organizational meeting. that is where, you know, there's more like an introduction to the company, to all the parties. Oftentimes it's like the first time to, you know, go through like maybe the business section, or at least spell out what will be the role and responsibility of each party. I have seen that to be a whole day session among all those parties that needs to be involved. You know, a lot of things is going to be vetted out initially, and usually whoever that's involved will be the working group going forward. So from there until what happens from the first meeting is that basically kickstart the process. From a finance and accounting point of view is then you will have to draft the before drafting financial statements will be determining what period needs to be disclosed in the financial statements, looking through all those, combing through all the accounting issues, transactions, really prepare a good draft of financial statements that needs to actually get, and they need to get audited. And then, while that's happening, audits happening at the same time, and going through that process, at the same time, you will have legal counsel probably reaching out to the, to the management team to get information to fill in other parts of the the S1 registration statement too. That includes, when I say other parts, that could be like there will be executive compensation part that they need information on. There's various disclosures throughout the S1 that you need some options informations or shareholding informations. So that's the bulk of work in the phase one. You go through the audit, and then at the final, when you come to a very close final draft, you have auditor sign off, board approval. Then that is when you filed, and then you will usually, before the initial filing, I do see very commonly people camp out in the printers. That's what we're saying. So that's part of the process where, all the parties go through, flipping pages, making sure that each and every pages are reading consistently from legal, business, financial standpoint.
Hand marking edits, even though it's 2018, somehow that's still a thing.
Yeah, you're working with pens and papers. That's still
believe it or not.
Yeah, and then you push the button usually we see majority nowadays people file confidentially initially with the SEC.
Yeah, so we're going to talk a little bit more in a minute about the Jobs Act and the definition of an emerging growth company. But basically what that does is it allows companies that are under a valuation of 700 million or so of public float, will be public float, can file under as an emerging growth company under the Jobs Act. And you can file confidentially at first, which kind of allows you to go through the SEC review process, privately, and as well as test the waters meetings. So you can have investor meetings, before you generally were able to prior to the Jobs Act. So that's definitely a huge piece of why we're seeing so much activity in the market.
Yep. And then obviously, as we said, the Jobs Act has allowed SEC to review things privately before it goes public. So you will receive comments letter. Usually we do see people come back with comments letter, receiving comments letter with SEC that could include from business sections, like SEC will comment on entire S1, but then you will have to flip through those letters to see, is there anything, relates to the finance type, or relates to the F pages. F pages means the financial statements pages or the MD&A pages that, the finance and accounting team will have to address.
So lately, I mean, luckily for all of us in the room, what we've seen is sort of a trend towards a lot fewer financial comments, and even frankly comments in general, compared to say the 2013 boom that we saw in IPOs, the comments have been a lot lighter, both financials and legal, business, etc. So it's kind of a nice, we've been through a few recently, and I've seen between 0 and 3 or 4 financials comments, which is pretty awesome. Easy to deal with.
So then obviously if there's any comments that needs to amend the initial filing, you would do that. At the same time, you revisit like whether there's a need to update, with quarterlies or additional financials periods information in there. And if you do that, don't obviously need to go through the audit or the review of the auditor, at least get their comfort through it. Then you'll file, you will file the amendments. And then towards the end, when everything is more like set in stone, that is where, we usually see where we submit the cheap stock letter to the SECs to get their initial blessing on that. At the same time, you'll update like pricing and pro forma information. If there's any reverse split or share split, you will update that. And once that goes through that, SEC would, they will review it and, declare that to be effective. And then that's when you go roadshow and you will have, your pricing and then close. That is when everyone then goes to NASDAQ and stand in front of the podium and pose for pictures or rings the bell.
Yeah.
So what's foreign private issuers? Sorry for this to be a little wordy, try to summarize it, but you can find the definition in, so SEC has a financial reporting manual, which is like the Bible, basically, for everyone who wants to go public and who is already public as well. Sometimes the SEC definition can be more, is different from, US GAAP, ASB definition, so wise to be well-versed in both. So definition in summary is, if you are a foreign private issuers cannot be, if you have someone who's owned more than 50% of a foreign company, but that owner is actually a resident of the US, then that company itself is not a private issuer. So, or if majority of the foreign company that has majority of your executive officers, directors are actually US citizen, or you have more than 50% of the assets of the issuer located in the US, or business of the issuer is mainly in the US, even though legally you're outside the US, you are not a foreign private issuers. So it's more like, if you meet all this definition, if you're a company outside of the US and you wanted to find out if you are a foreign private issuers, go through this exceptions to find if any of this actually meets your criteria.
Yeah. What will generally happen is sort of companies are able to, and there's been quite a trend in the last 6 months or so, maybe even year now, of companies doing this. They'll start out as a foreign private issuer, as May is about to talk about. It provides some relief in comparison to what a domestic issuer is required for reporting. One being semi-annual reporting as opposed to quarterly reporting. So companies will tend to start out as a foreign private issuer, and then they'll generally finance themselves out of the definition of it. You do enough offerings in the U.S., bring on new investors, all of a sudden you won't meet the criteria anymore. So, get into some of the companies that have done this. So there's a significant amount of UK companies that have done it recently. And their risk factors in the registration statements will say, by mid 2019, we may not meet the definition of a foreign private issuer, and our reporting requirements will be more stringent. So.
Yeah. So if the company is a foreign private issuer, you have to test at least once a year on the last business date of the most recently completed second fiscal quarter. So you have to test once a year to make sure that you meet that definition. And obviously for foreign private issuers, these are the forms that you used, unless you opt to use the domestic rules, but and you can actually adopt IFRS instead of US GAAP. And if you issue financials less often, because in the US you will have to issue your 10K for the annual, and then you have to issue every quarter you have to issue financial statements. But if you're a foreign party issuers, you only issue it half yearly.
Every company is a little bit different, and what you're comfortable with and what you require. But for the IFRS versus GAAP, what we tend to recommend is, if you're going to go and you're going to continue to finance in the U.S. and build up in the U.S., you might as well do your conversion to GAAP before you go public. Doing a conversion to GAAP while you're a public company is not ideal. So do it ahead of time, since eventually you'll have to do it anyway.
So JOBS Act, what is it? So in 2012, April 2012, President Obama signed into the Jumpstart Our Business Startups Act, and it gives a few reliefs. And one of the key ones is the creation of the emerging growth company. So what's an emerging growth company? Currently, the threshold is any company with annual gross revenue less than 1.07 billion in the most recent fiscal year. So what are the relief? So basically, you can file confidentially, do you want to talk more about what's the 15-day raffle?
Yeah, that's okay.
Okay, and then you will sort of exempt from from disclosing the relationship between executive comp and performance, exempt from disclosing some CEO pay ratio, exempt from auditors' attestation on internal controls on 404.
Or at least as long as you meet the definition of an EGC, or for 5 years. So, generally nice relief if you're not a billion-dollar company yet. Keyword yet.
And then so instead of disclosing 3 reporting periods, you disclose there's 2 years of audited financials only. There's no need for historical quarterly information, and also 2 years of summary and selected financial data, which the last point is shown in other places in the S1. So except in certain cases, some underwriters may want more than 2 years of financial data. That is only exception. But obviously, this all depends on the industry and how mature the company is.
Exactly. Yeah. So what that means essentially, by the letter of the law, you're not required to have more than 2 years of financials or the quarterly information. And there's other relief you can get under the JOBS Act. One most important, I think, for our crew here is the relief from adopting new accounting guidance. You can adopt on the private company standards as opposed to public company standards if you're an EGC. However, the underwriters are going to want you to be in line with your peers. So the peers that are already public companies. Companies that are revenue-based or growth-based, earnings-based, they'll want to show the ramp of revenue. So, you have a software company. You want to be able to see that over time, quarter by quarter, or for a longer period. So go back to that, the oldest, the 3rd year. Same for adopting new guidance. It's sort of looked upon as kind of, the JV, we'll call it, kind of you're not on par with all of your peers if you're adopting late. The one thing I'll say is I've seen a couple companies elect this lately and adopt standards later because of the new revenue guidance. So that's kind of, if you want to go really, really fast, the adoption of the new revenue guidance is going to take some time. So companies are electing to say, punt that 1 more year. Get public, and then we'll worry about it when we're public.
Cool. And also, whereas, it's audited or unaudited numbers, we'll just need to make sure that, if we need to get the comfort letter from the auditors, it's important once we have decide to go public, to involve the auditors early, to talk about expectation, what kind of sign-off we want. I do have an instances where, especially when you have a switch of auditors, and if part of the financial period is going to be in the registration under the old the previous auditors, just make sure that you engage them and the current auditors, just to make sure like what level of comfort that they need and what kind of sign-off that they need from the previous auditors.
Yeah, it's a similar thing for the for foreign private issuers. While you're not required to have more than semi-annual information, and you wouldn't even need the semi-annual information, so let's say your June 30 numbers, until 9 months has passed, the comfort letter will have different requirements. So an auditor's comfort letter may need more up-to-date financials. So you may wind up having to prepare formal quarterly financials anyway.
Yep. So EGC are permitted.
Sort of talked about
yeah,
this
we talked
already.
about this.
Yeah.
So then this is more like age of the financial statement. So 135 days from the the reporting end date is the 135 days is the key. So for example, I have a little table there. Obviously the last effective date is just approximate. You probably need to add them up, depends on the year and the days, and so that is when your financial statement goes stale, and that is when you will be required to actually file new, include the period into your registration statements.
Yep. So this is definitely an important thing to think about, because what that means, you'll need the most recent quarter generally, and also the quarter that's comparable with that. So we're talking this year, right? So we're going to file an S1 or an F1, or assume an S1 for purposes of this, in September. And so that means we'll need June 30th financials, June 30, 2018. We'll also need June 30, 2017 for the comparable period. So, as a private company, you're not required to do such a hard close on a monthly or quarterly basis. So generally what we find is that our clients are needing to go back and look at quarter cutoff, make sure that our financials, in any period that could see the light of day, are clean.
And on our very last topic, then, that will be accounting considerations. So there's a couple of things that we need to be aware of. Obviously, from my experience, certain information in here, they are very US GAAP specific. So those are things that we, as part of the process, should be actually identified pretty much up front. And just to point out though, so business combinations, there's a difference between US GAAP and UK, IFRS. There are some certain differences, but there's additional difference because the SEC has a different interpretation of what the business is. So when there's a business comp, there needs to be additional, consideration to that. And we definitely won't be able to cover the, differences like the accounting considerations of each of this topic today. But so if there's opportunity in the future, we can sort of talk about that in.
Yeah, and maybe just the one thing I would add on that kind of front is, if your company is thinking about it, or, if that's a goal for the company, I would just, as the finance, personnel, I would act as if you're a public company. So none of those things are excluded from private company guidance. So if you're a private company, you can account for everything just like you're a public company. So your clean closes every quarter. What'll happen is the board, the investors, the bankers will come, and all of a sudden it will be, full speed ahead. We're going public in 60 days. And it all of a sudden turned to finance and accounting being the thing in the way, or the audit being the thing in the way of this IPO. So, the best advice I can give is kind of prepare yourself ahead of time and kind of always be acting like it's coming. Same with the auditors. Managing them is the same way you would on a public company audit.
You ready for questions?
Yeah.
Good. So
Let's
move a little closer to the camera. I know, Ryan, the camera's
Killing
shy,
you.
but we're going to get you over that, right? So I don't know whether we're going to get through all these. I'm going to start at the top and go through them, and we'll see how far we go. Some of these are only going to be like a comment. Okay, so the first one is you may want to distinguish between a confidential submission and a public filing, as it makes a big difference to the availability of information on Edgar during the SEC review process. So I think that is, do you agree with that statement?
Thoroughly agree. So to the public, that a confidential filing will not see the light of day.
Right.
So until we call it sort of a public flip, what will happen is once the SEC comments have been cleared, the company has the most up-to-date financial information and business information, you'll flip it to being a public document.
Right, and that was from Nicole Pinder, so thank you, Nicole. So next one from Ian Lehman is, what proportion, I don't know if you know the answer to this one, but what proportion for the number of companies and value of NASDAQ companies are non-US?
Do not know the
Yeah,
answer.
I wouldn't know that. You can
Great
guess.
question, yeah. Yeah. Although I can say we've probably had 10 IPOs in the last 6 months or so, just as CFGI clients, and 3 of those are foreign issuers. So.
That's a good enough answer. And we'll go with that. We'll go with
pretty good.
We'll go with 30%.
Yeah, I don't think that's a representation, but hey.
Okay, so the next one is, what impact may cryptocurrencies have on raising money for young companies, and do you see this market being further regulated?
I would hope it's further regulated, but otherwise I'm clueless.
Anything to add?
Nope.
Okay, and so the next one is, a direct listing appropriate for anyone other than Spotify?
Not in my opinion. They don't need the money. That's the only reason you would do that.
Yeah. So next one coming up, that was from Peter Gill. Given the non-traditional approach that Spotify recently took, so it carries on to complete its listing, and it's actually the same thing. Do you see other companies exploring it? I guess some could, but it's going to be a rarity rather than a norm. Is that fair enough?
Yeah.
Yeah, I think it's a financing transaction,
Exactly.
And Spotify did not use that. For Spotify, it was a liquidity transaction.
Yeah.
So unless you don't need the money, which would be a very nice problem to have.
Can you just talk to why the confusion there? And what would be the business active plan for Spotify?
So Spotify wasn't raising any money. Most of it are going to go through this process, want to sell, sell their shares, new shares to public companies.
Yeah.
So that brings in the volatility that you see for a new public company, which is why Spotify didn't do that. But unless you're sitting on a whole bunch of cash.
Wasn't Spotify just looking to release or release cash back to the original owners who had equity, rather than, you say, raising new?
Yeah.
So it was really,
Exactly.
they wanted the cash out, and it was a way for them to do it, whereas most companies,
Purely liquidity.
they're
without-
issuing shares, bringing in
More
money to
new
grow
money.
the-
Yep.
Okay, so next questions. A couple left. I can see you're excited about this. So, right, and you might know what these numbers mean. I don't. So I'm going to say them to you and assume you do, right? So for the SX312 age, hope you with me so far? Because I'm lost, right? Of financial statements.
Yeah.
Would this not depend on domestic versus FPI? And then if a domestic issuer, their filing status?
Yeah. Do you want to talk about it or do you?
I don't know the FX.
So it's just age of financial statements. So
Okay.
our slide that showed the quarterly financials and the kind of the expiration or staleness dates.
Yeah.
So that's for domestic issuers.
Yeah.
So basically, if in a registration statement, those rules apply for domestic issuers. For FPIs or foreign private issuers, foreign public issuers, the age of the financial statements cannot be more than 9 months.
Yeah.
So, if you're a calendar year-end company, the age of your financial statements, you could have year-end financials all the way up through filing through September 29th of the next year. You get to, I guess, September 30th. You get to October 1st, and then that would require 6 months or half-year financials. So that's kind of the part of the nice relief you get as an FPI.
Another acronym for you that you're gonna know the answer to, because it was on one of your slides earlier, right?
All right.
So by when does an EGC, which is an easy one for you, registrant have to comply with Section 404?
Yeah.
Sarbanes-Oxley. That's the bit that I didn't get, is Section 404. So I'll pass that to you.
Give it a stab.
So, yeah, that's a test question. So once you come out of the threshold, right, then you will have to, the question is when it has to comply. Yeah, usually what we...
2 pieces. So.
Yeah, so usually what I've seen was there's, once you gone public, you have like 2 years, then you have to actually be in compliance with the 404. The 2 years is counted towards the second, effective second 10K.
Yeah.
Yes.
Yeah. First full year of being a public company, and maybe even just back up a step.
Yeah.
So 404, what that is it's regarding your internal control environment.
Yeah.
And so if you're 404A compliant, or excuse me, subject to 404A, that means management of the company has to opine on its own internal control environment.
Yeah.
And that has to be included in your annual report.
Yeah.
And so that is required in your second 10K. So the second annual report, so basically for the first full year that you're a public company. And so that would be, generally CEO and CFO signing their names saying, we have effective internal controls, or not, if it's determined that we don't. 404B means that our external auditors are opining on our internal controls.
Yeah.
And so the Jobs Act provides relief on that for 5 years, unless your public float, which is generally your market cap excluding any internal, related party investors, is over 700 million. Or your revenue goes over $1 billion, 1.07 billion. The 0.07 came from inflation.
There's my question, Don,
Yeah.
right? Okay, so I'm going to follow on with that with another one on the same, and this could be a fun one. I don't know. So the question is, what happens if an EGC loses its status as an EGC during its IPO?
You generally wouldn't. So I think for the most part, your investors would be considered related party investors. So I think it would be very rare to lose EGC status during an IPO, unless your revenue, I suppose, goes over the 1.7 billion mark. And then that's just a really good problem to have, and you should, hire Daniel and his team to get your controls into shape.
Right. So a couple more questions, and then we'll throw it open to the room, and then we're going to be done, right? So a little bit further to go. So next question, and I'm sure this is, if you've got a piece of string, you could figure out where it goes, because the question is, what are the fees involved in an IPO?
So basically, from that, obviously, you will have a very expensive lawyer fees, and as well as the next one will be your auditor's fees, I think, and then there will be, other like filing fees that you need to pay, and then printers fees, and if you hire consultants, those are the ones that you will be, have to bear. So those are the underwriters. The underwriters fee, definitely. That one is like the biggest.
7% right off the top.
Exactly.
The underwriters. So that could be a huge number.
Yeah.
But I would say go check out an S1 registration statement. That's information that has to be disclosed publicly.
Yeah.
So you can go in and see, attorneys' fees, accountants. We're a lot cheaper.
Yeah.
Et cetera, and underwriters, et cetera.
Yeah.
That'll be right in there. The big numbers.
Excellent. So what we're going to do naturally, we're going to throw it into the floor to see if there's any questions from the people in the room. This is your moment, guys. Can you, when you get asked the question, can you repeat the question back and then answer it so that we can get it recorded?
You said how there are fewer questions being asked now as part of the filing process and the general process. Just interested to feel why it is, whether it's higher quality submissions or different.
So the question is, we have observed there's fewer SEC comments coming back nowadays. So whether it's because of the quality of submissions or whether it was a different approach by the reviewer. And
Ryan's going to answer.
Yeah. I think there's a couple of reasons. I think so one is the SEC is divided by industry. So one would be, so you can look at the IPOs that have happened. It's primarily life sciences. It's probably 80% of the IPOs, also with some tech there. And so the division of the SEC that handles that is definitely busier, a lot busier than they used to be. So I think that's a big part of it. I think the ability to kind of clean things up through the confidential filing process is helpful. That's probably the main thing.
Excellent. Emma.
I had a comment and a question. The comment was on the confidential filings. Don't forget they become public.
Right.
Later, not so confidential.
Yeah, just to repeat that for the people online. So the comment was, that the confidential filings, they become public documents. Generally, you should anything submitted to the SEC, including your responses to their comment letters, those do become public documents, even if they're confidential initially.
And the question was, what happens if you do a follow-on within a year of IPO? What forms do you need? What are the different things you need?
I think generally, so the question, was what happens if you do a follow-on offering, within a year of the IPO. And so some of that I would say is a lawyer question. I defer a little bit of that, but the forms you generally are going to need is an S3, to register those shares. I've seen follow-ons that involve an S1. Again, I think that's a little bit rare, but S3 is sort of the general form.
I think it is something to do with the S1. Do the whole thing again.
If it's within a year, okay. Yeah, that's where I'd defer to one of my lawyer friends.
Any other questions? We're at 50 minutes. I think that's good.
yeah.
Pretty
So
good.
with that, I'm going to pass to Daniel to close us down.
Yes. Well,
Okay,
thanks,
cool,
everybody.
Thank you.
okay, so thank you very much, May and Ryan. That was very informative. And this concludes our first webinar of the Doing Business in the US series. There will be more to follow, and you will be able to download this webinar and the handouts, the deck that accompanied this webinar from the website. For those who haven't already, join ACOS's LinkedIn group for information on future events, and also the ACOS website, acos.org, to sign up as a member, and you'll get notified when these events happen in the future. So again, thank you very much, May and Ryan, and we will see you in a future webcast. Thank you.
Thank you.
Thanks all.